fantastic piece by Jed Babbin in the Higher Ground Times. It's about the current uh, decision by Lloyd Austin, Secretary of Defense, regarding the pretrial plea agreement that he rejected. And we'll read it together. So September 11 plea deals are probably the best we could do under the law. And, even though I'd rather not see a plea deal, but we're most likely never going to see a trial because, you know, they made these confessions under duress. Now, remember, even if they are guilty, how could you believe them? See, this is the war that we're in. We're in, knowledge and belief. The government doesn't want you to not know anything. They want you to believe whatever you want. It's not definitive. What they don't want you to know is that these people were tortured and that they ruined the case by doing this. Now, their excuse is that we needed to do this to stop further attacks. But they didn't even have to do that. Take, for example, the capture of Ramzi Youssef, the mastermind of the 1993 World Trade Center bombing and the Bajinka plot. They didn't torture him, and he told them everything. Abdul Hakim Arab was tortured by the Philippines, but later on, he related the Bajinka plot to Colonel Rodolfo Mendoza when he was just given a hamburger. Abu Zubaydah was captured in Pakistan, and he told everything to Ali Soufan, and he wasn't tortured. It was only when the CIA got involved that the CIA tortured these people. The FBI didn't torture these people. Now, later on, through the CIA SEER program, the torture program, the enhanced interrogation techniques, the FBI knew that these people were being tortured, yet they handed in their questions to the CIA, knowing full well that they were indirectly being involved with torture, but they didn't have to. The plea agreements for the three September 11th defendants reached July 31st, tossed 2 days later by Defense Secretary Lloyd Austin, naturally drew considerable anger from many of the surviving family members of the 2,996 people who died as part of the attacks. For justice to be done, all three of the defendants, Khalid Sheikh Mohammed, Wali bin Atash, and Mustafa Hassawi, should be executed. Now, as you can see, there's Amr al-Baluchi, who's not involved with this disagreement. And I've spoken with one of his counsel, and basically she says to me in the podcast that we've done, that they were going to basically not be part of this plea agreement because Amr al-Baluchi was alleged to have been a participant in these attacks through providing logistical support, financial support to some of the life in the hijacker. These are all alleged, by the way. So they weren't. He wasn't part of this plea agreement. But in nearly 20 years of their cases being considered by the military tribunals of Guantanamo Bay, Cuba, these plea agreements are probably the best we could do. That is because the evidence against these terrorists and others is admissible because of a change in the law engineered by Senator John McCain and other evidentiary concerns. That evidence obtained through waterboarding is inadmissible at trial is a large part of the problem. Thank you, State Department, Donald Rumsfeld, and the White House lawyers like John Yoo and Alberto Gonzalez, David Addington, these people that circumvented the Geneva Convention for Foreign Combatants, that they weren't afforded rights because they're not U.S. citizens. When Khalid Sheikh Mohammed and other al-Qaeda terrorists were waterboarded, it was legal under the U.S. law against torture, but U.S. Code Section 2340. The courts held that under the clear law, application of pain to a prisoner was not torture unless it was lasting physical or psychological harm. One of the defendants, Ramzi bin Ashib, was declared mentally unfit because of his torture. So he can't be tried. How about that? That means soon enough, all four of these left, they're not going to be tried. Because waterboarding had been used on hundreds of U.S. pilots at the Survival, Evasion, Resistance, and Escape, or SEER program. And because it caused no lasting harm to them, the Justice Department concluded that waterboarding was legal. That lasted until 2005, after 3 years after waterboarding was last used on terrorist prisoners. Enter John McCain. Whatever you thought of him, he was a war hero. After his aircraft was then shot down, he was imprisoned by the North Vietnamese from 1967 to 1973 in the infamous Hanoi Hotel Hilton with other captured Americans. He and they were subject to beatings and other forms of torture. About 20 years ago, I interviewed several of McCain's fellow inmates in Hanoi Hilton. To a man, they told me that they believed would not be alive for his heroism. One might have thought that McCain would want American law to be crystal clear on the subject of torture, and one would be wrong. In 2005, he sponsored and pushed through Congress a revision to the law on torture. That amendment befogged the law on torture by adding that, quote, no individual in the custody or under the physical control of the United States government, regardless of nationality or physical location, shall be subject to cruel, inhumane, or degrading treatment or punishment, end quote. You know, it's ironic because McCain is a war pig. He was for the Iraq War. Excuse me, that killed over 1.3 million people, 1.3 to 1.5 million. We don't know the true number. And I would say that that was inhumane, degrading treatment. And I would consider that punishment unneededly because they were blamed for what? The 9/11 attacks. It's kind of ironic. Instead of defining those vague terms, the McCain Amendment punted, saying they should be defined in accordance with the Constitution and U.S. reservations in ratifying the United Nations Convention Against Torture. As the post-McCain Amendment law stands, waterboarding and other enhanced interrogation techniques are illegal. Logically, even if waterboarding was legal when it was done, evidence obtained by it is inadmissible in a military tribunal or federal court under the rules of evidence. Now, the CIA knows this. They had to have known this. Now, they're not a law arm of the United States. That's the Department of Justice, the FBI. CIA does have literate people in terms of judicial law. And they should know this. Now, remember, too, the Pentagon's involved because Donald Rumsfeld signed off on this. Are we led by really dumb people? Like, I mean, that could be a point. But I'm not. I doubt it. I think that these people were basically. Did they believe that they were going to stop a next attack? Yeah. But then they had to think about the long run, right? They had to think that, hey, listen, we can't use this testimony as it'll be inadmissible. Maybe they weren't thinking that much down the road. Reactionary, like most right-wing organizations are. Most of the evidence against KSM and his ilk, including confessions, was probably obtained by waterboarding, so their conviction of a capital crime is almost certainly not in the cards. The other problem is the other evidence against Khalid Sheikh Mohammed and others is likely derived from intelligence information. Unless there are audio recordings of their voices or emails or texts they sent or received, most or all the intelligence information would be ruled as hearsay. Now, I interviewed Nick Fielding, who co-wrote the book Masterminds of Terror with Yoshri Fuda. And why is this important? Because the book is based upon the interview that Yoshri Fuda from Al Jazeera did with Khalid Sheikh Mohammed and Ramzi bin al-Shibh. Is Yoshri Fuda lying? Why would he lie? In fact, it was Khalid Sheikh Mohammed's emissaries that contacted Al Jazeera, saying if they requested Yoshri Fuda because he's Arab, right, Muslim. And he has a sharp reputation. So after some security concerns, you had to go through cars and taxi, blindfolded, taken to a safe hotel where he stood there for a couple of days. And then the last day he was taken by a car, blindfolded, taken to a safe house in Karachi where he met Khalid Sheikh Mohammed Ramzi bin al-Shibh. I think it was for 2 or 3 days. He videotaped them. And they weren't tortured. Remember, at this point, this is 2002, by the way. And they told him that they were behind the 9/11 attacks. Now, according to Nick Fielding, when I interviewed him, he said there's videotape of this. The CIA has it. What's the need for torture? Why can't this be used as evidence? What was said in that interview, according to Yosef Fruta, was Khalid Sheikh Mohammed and Ramzi bin Hashim taking credit for planning and orchestrating the plane's operation, showing them maps, plane stubs of the planes that were hijacked and everything. It's all on video. Now, the video had to stay behind because they wanted to scrub the faces off of Khalid Sheikh Mohammed Ramzi bin Hashim. But then all of a sudden, Ramzi bin Hashim is captured and then Khalid Sheikh Mohammed. The video, put in their fielding, it's in the hands of the CIA. The plea agreements, of which we know very little other than they rule out the death penalty for the three, remain under seal in the military tribunal. Perhaps the defendants agreed to life in prison without parole. Perhaps the agreements call for moving the terrorists to U.S. jails, which would be a terrible mistake, but consistent with President Biden and Vice President Kamala Harris' desire to close Gitmo. Meanwhile, Mr. Austin's action is rejecting the plea agreements will be challenged by the defense lawyers as illegal command influence over the proceedings. Command influence is defined in Article 37 of the Uniform Code of Military Justice. It provides that no commanding officer or convening authority can censor, reprimand, or admonish any member of a court-martial proceeding or interfere in the exercise of any proceeding. Mr. Austin, as Secretary of Defense, is the highest convening authority in the military justice system. That's why he made that decision. The defense lawyers' argument attacking Mr. Austin's revocation of the plea agreements is not entirely clear, but it may suffice to cancel Mr. Austin's actions. So far, the military judge on the cases has not ruled and has told the parties in so many words, calm down. Khalid Sheikh Mohammed was arrested in March of 2003 and taken to one or more secret locations where he was waterboarded to extract information on everything from Osama bin Laden's hideout to his and others' involvement in the 9/11 attacks. It would be tragic for him and the others to escape capital punishment. Nevertheless, the plea agreements are probably the best we could do under the law. And Jed Babbin is a national security foreign affairs columnist for New York, Washington Times, and contributing editor for the American Spectator. It's a very good article. I'll actually put it in the description. But as much as I don't want a plea deal for obvious concerns that we'll never know what the government had as information until 30 or 40 years down the line when it's declassified what they did have. But this could be a problem because by then a lot of people would have to escape facing justice. And I'm not talking about just the defendants in this case, but I'm talking about people within the NSA, the CIA, maybe Saudi and Israeli intelligence who are monitoring these people and may have had specific information where this could have been stopped. All right, guys. Listen, that's the end of the video. Thank you very much for tuning in. See you next video, everybody.